Good morning, folks. My name is Diane Drain. I am the co-executive director of ACBC and also the co-chair with Lisa Thompson. And whoops, it's reminding me to start the recording. So we welcome you today, and we have a wonderful program. Denise Quinterri is here to talk to us about ethics questions. And I'm sure I just slaughtered your last name. I'm sorry, dear. A little bit of housekeeping. Denise wants to answer the questions at the end of the program. So please go ahead and post your questions into the chat. Both Lisa and I will help her in dealing with that, but we're not going to interrupt her presentation. The materials are going to be posted periodically throughout the program. As far as the materials that Denise prepared for us, your CLE certificate will be posted at the tail end. The materials are also available on the ACBC website. Please make sure you keep all of your videos muted. I'm looking here, make sure that I know all the names, because the only way we give CLE credit is to people who actually use their names. And it looks like everybody's done good there. So Lisa, take it away.
So my name is Lisa Thompson. I'm on the CLE committee for ACBC, and one quick note for everyone, because I just did this morning, is you've got to turn in your affidavits with the State Bar of Arizona by Sunday. So Sunday's our deadline, so make sure you do that. I had the oh no moment, and so that's what I did first thing this morning. So I just wanted to make sure that everybody is aware. I am really excited to have my friend Denise with us today. She has worked at the state bar. She focuses her practice on ethics. I know many people that are on this call, some from Spain, who have asked her for sage advice. And she has been my attorney, helping me with some fee issues. And I am so excited to also work with her. She helps set up CLEs for Pima County Bar Association. So she's definitely committed to providing information to the legal community. So without further ado, and Denise, if you want to say more about yourself, please feel free. I'm going to hand it off to you.
Thank you. And I appreciate all those nice things you said very much. So this is a program actually that we did put on for the Pima County Bar. And I have just edited it a little bit for a few things that changed or that I thought weren't necessary. There's my information, by the way. So if anybody does want to know more, it's in there. The only thing I would add is I do a lot of character and fitness besides bar matters. So we put this together, or I put this together, top 10 questions. Of course, I can't be absolutely positive that these are, statistically speaking, the top 10 questions that lawyers like myself and the ethics hotline get. But what I did was talk to my friends who've been on the hotline or the ethics council, and asked several of them to give me their top 3, so they weren't forced to do a whole bunch of thinking about it. And between all those, I came up with what I think is probably pretty fair representation of the top 10 questions that we get. Now, hopefully, if you've already asked one of these questions and you're like, oh, I already know this one, well, hopefully there's some that you don't. And either way, I find when I do it, it's helpful anyway to refresh yourself on the rule, because they don't come up all the time. And also our rules, if you don't know, are constantly changing. So it's a good idea to look back at things you think you already know periodically anyway, because the rule may very well have changed or been updated. There were a lot of updates from the whole changes about the ABSs, as I'm sure everybody knows. So this one was pretty much on everybody's top 3 list, which is why I put it as number 1. Do I have to report any attorney for X, meaning whatever? So when you get these calls, a lot of times the lawyer does want to report for whatever reason. They're wanting to report and they're hoping you're going to tell them that they have to. On the other hand, they might be hoping that they do not have to report. It's a frequent topic, but the actual discipline cases are not frequent sanctions for this rule. And that may be because many lawyers and judges actually do report, so they're not getting in trouble for it. I think our Arizona judges report things pretty frequently. I'm in a national group, Association of Professional Responsibility Lawyers, and sometimes this topic comes up because, you know, across the states, it's there's a variance on whether you have to report or not. In Arizona, you do. So, example, I was just giving an example. Annie works for me and she missed a statute of limitations on a case and then she lied to the client about it. Do I have to report her to the bar? What if the client already reported Annie to the bar? Do I still have to report her? So this is just examples that we'll come back to after we look at the actual rule, what the rule says. The rule is 8.3, reporting professional misconduct. And as is the case with most rules, the language is very important, the specific language, and that's the first thing you're going to look at whenever you're trying to figure out what to do under a rule. So what does it say? It says, a lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer, shall inform the appropriate professional authority. And then same thing for if you know a judge. So on my printout here, I have highlighted things. The important words here are knows, circle knows. And then the second important thing is it's a substantial question. And then the third thing is, what is it a substantial question of? The lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Okay, so how do you know? Because that's the most important thing. Do you suspect, or you think, or do you actually know? Now, if you suspect or you think only and you don't actually know, you don't have to report it. That does not mean that you can't report it. You can, but you don't have to. How do we know what is meant by no? In our rules, it's a term of art, basically. Well, maybe not a term of art, it's an actual defined term, and it is defined in ER 1.0, which is where you find a lot of definitions of certain terms. We can assume actual knowledge as defined in ER 1.0, not just suspicion. Actual knowledge may be inferred from the circumstances. I'm going to move to the next one. The next one is not, this slide isn't really that big of a deal here. It's just adding, because of all those, the new ABSs, they added ABS in here and legal paraprofessional. But D is relevant. This rule does not require disclosure of information otherwise protected by ER 1.6. That's the confidentiality rule, or information gained by a lawyer or a judge while serving as a member of an approved lawyer assistance program, to the extent that such information would be confidential if it related to the representation of a client. So what this basically means is, you know, if it's when you learn it in the course of a representation, it's confidential, right? Because we know everything about representing your client is confidential. So you need to talk to the client before disclosing it, because you don't have the authority to just go report it to the bar, even though 8.3 tells you to report things to the bar, because you have to have client consent. That you can talk about a little bit, or excuse me, you can get more detail about in the comments, which I don't know if I put here. No, I guess I just put that we're going to talk about. I already talked about the language, knows, substantial, etc. Now, the comments to the rules give you some further explanation about the cross reference of confidentiality. So like I said, it's up to the client, but a lawyer, the comment says a lawyer should encourage a client to consent to disclosure where prosecution would not substantially prejudice the client's interests. So you have to think about that, you know, and talk to the client about it. And that part of it does come up a lot because, you know, the client may be hesitant to report it. And depending on what the issue is, you know, you want to talk to the client about what things are so important that they should really consider it, like if there was theft or dishonesty or something, you know, really serious where this lawyer could go and hurt someone else. The comment 3 talks about the fact that if a lawyer had to report every single violation of the rules, the failure to report a violation would be a professional offense. Such a requirement existed in many jurisdictions, but proved to be unenforceable. So this rule limits the reporting obligation to those offenses that a self-regulating profession must vigorously endeavor to prevent. And that's where we get where we go back to the language of substantial and the seriousness of the offense. And knowing. Then it also mentions, where do you report it? That's a sub question that comes up a lot. Generally the bar. I mean, the bar is always going to be appropriate. There are times when somewhere else you might want to report, also like a judge, but the bar is your number one place to go. And if you have reported it to the bar, you're not going to be in trouble for not reporting it to someone else, most likely. Comment also explains that this duty to report does not apply to a lawyer retained to represent a lawyer. That would be me. So, or people like me, right? If you're representing a lawyer, I'm representing you, you don't have to worry that I'm going to report to the bar what you did, okay? Same thing with malpractice lawyers representing lawyers in malpractice cases. So 1.6 drops there, okay? And then it talks a little bit about the LAP programs again, or actually we call in Arizona the MAP programs. And I'm sure everybody knows what those are when, you know, you've got substance abuse issues or depression issues or whatever, and they're seeking help. When they're seeking help from these programs, the people in the programs don't have to report it. Or if that was the case, nobody would seek help. And of course, we want to encourage the public policy of seeking help. And then I have examples. I can't see my clock, so I'm talking a little too long on this one. Sorry. I'll go through these kind of quick. So some examples of when someone has what is clearly substantial conduct that needs to be reported. We can figure out those examples from ethics opinions and the few cases that we do have. So suborning perjury or destroying or altering documents are serious and material offenses. If you know about that, you have to report it. Rape or a criminal act of violence raises a substantial question. You have to report it. Stealing, misappropriating firm fees, and that's serious impacts on a lawyer's honesty, has to be reported. There is an old ethics opinion that talks about failure to file income tax returns being a reportable offense. Lying to a client, reportable offense. As far as there being a few cases, so Pat Sallin has an article on this. If you ever get stuck and you want to look it up, I had it, but I can't see it. But it was something about Himmel angst, I think was the title. But if you searched Patricia Sallin in 8.3, you'd find her article. And in there, she mentions a specific case, which I did just want to reference because the lawyer got diversion, and diversion is confidential now, so you wouldn't be able to find it, but it is in that article. And the example was a lawyer who knew that their associate or partner, I forget which, had lied to a client, falsified records. I believe trust account money was also involved, and did not report. I think part of the explanation, if I recall in that case, the lawyer thought, well, the bar already knows or knows some of it. And because there were some mitigating factors, the lawyer only ended up with diversion. And as I said, diversion not being public anymore, you would never know if it wasn't for that article. But the lawyer did receive diversion because ultimately, you know, you can't be sure the bar knows everything. If you know things, those types of serious things, you need to report it just to make yourself safe. And there are other cases. I think Pat's article says something like, as long as she worked there and she never had any, but I've had a couple, and there are a few that you can find on the website if you really go looking. So back to the Annie hypothetical. Yes, you have to report Annie, even if you think the client already reported Annie. You have to do it, which is the example I just gave you about the Diesel case. So moving on. Do I have to report myself? There's another question that comes up. No, you do not have to report yourself. In most instances, there are a few instances where you do have to report yourself. Limited circumstances, okay? Well, that's what I just said. So this one, 61C, I can never remember where it is, the reporting requirement, because 61C is about other things. But for some reason, in the middle of 61C, or in the middle of Rule 61, it says that within 20 days after entry of judgment of conviction of a misdemeanor involving a serious crime or of any felony, the lawyer has to report it. Okay, so you have to report certain crimes. Then the next question always is, you know, what is a serious crime? Is DUI a serious crime? That's a very common question. I will tell you that those of us, you know, who do this, we used to have like group emails all the time when Mark Harrison, bless him, was still around. And I remember us having a big discussion debate, Arizona lawyers, not national, about whether DUI is a serious crime. And we argued, and I don't know that we ever reached agreement. In my opinion, I did not think it was, and I was going on a Supreme Court case by Justice McGregor called Derendale, Derendal, where she talked about she was talking about serious crimes in the context of when there's a jury. So to me, I was like, if it's a misdemeanor, maybe not. But I don't know these days how our DUI laws have changed. And what I do know is that certain people on the probable cause committee at the bar, well, not at the bar, because the probable cause committee is at the court, but they believe it is. They believe it should be reported. So in abundance of caution, you know, if you get a DUI, you probably should just go ahead and report it. For a low level DUI, you can reach a very good result like diversion and not be significantly harmed by this anyway. Probably get some help that, you know, you may or may not need, but it certainly wouldn't hurt you. And hello, Linda Brown. The other thing, which I didn't have on this slide, but was reminded when I was looking back at this today, is reciprocal discipline. That would be another limited circumstance that you do have to report yourself. So that means if you're also licensed in Iowa and you get a reprimand in Iowa or whatever state, I just picked that one out of the air. Rule 57H of our Arizona Rules of Supreme Court does say that you have to report that reciprocal discipline within 30 days, shall report. So those are the two limited circumstances now that you're required to report. Now, does that mean you should never report anything else? That's kind of a, you know, a situation by situation thing. You probably, if there's something else you're worrying about reporting, you probably want to talk to an ethics counsel. I'm not here selling my services. You know, honestly, I prefer I prefer just answering bar charges and representing character and fitness to the calls. You can call the ethics hotline. You can call any of the, Pat Allen. You can call me. I'm not saying you can't. You can call Nancy Greenlee. You can call all the people who do this, and talk to them about it, because in some cases, even if you're not required to report something, you might want to self-report because it could help you in your discipline case, like, if it's something that's going to come up anyway. I can tell you there's a range of examples of people who have called me, between people who are worrying, freaking out about something that they do not need to freak out about whatsoever, to people who are wondering about something that is something that they have to worry about. So talking it over with somebody is always a good idea, but the answer to whether you're required to report your own conduct is only in limited circumstances. Okay, number 3. This comes up, always surprises me. It comes up more than I would think it should, but it does. It comes up a lot. Can I fire my client? Can I withdraw? Can I tell the court what a jerk the client is when I'm withdrawing, presumably, right? So, for some reason, a lot of lawyers have this impression that they can't fire a client, they can't withdraw, and that's not the case at all. Sometimes you need to, there's an expression everybody says, so I don't know where it came from first, but we're not a bus, okay? We don't have to take everybody. We're not a public bus that we have to take everybody or put up with everybody either. We have a rule that tells us when we can withdraw, and that's the rule you want to look at, or fire, which is the same thing as withdraw. So it's ER 1.16, declining or terminating representation. And there's sometimes that you must withdraw in there, and then there's sometimes where you may. So the first one that I put up was shall not, see, except as stated in paragraph C, a lawyer shall not represent a client, or where representation has commenced, shall withdraw if the representation will result in violation of the rules of professional conduct or other law, if the lawyer's physical or mental condition materially impairs the lawyer's ability to represent the client, or, of course, if the lawyer is fired, then pretty much they have to. And then paragraph B has the may withdraw examples. So you do have to consider whether the withdrawal can be accomplished without material adverse effect on the interest of the client. And I think that's probably the language that makes some lawyers afraid that they never can withdraw, or that it's, it might not be a good idea. So you do have to consider the material adverse effect. That's only when you're looking at a may. It doesn't apply to the shells, obviously. The shells you have to. So may is like, this client is annoying me. Or this client is terrible, or this client is, whatever the bad things about the client. And you want to withdraw, but you're not falling under the shell. So then you look at these factors, and you look at what would be the material adverse effect. And that there are other things are examples of when, like, the client's pursuing a course of action that you reasonably believe is fraudulent. So here it's a little different than knows. Knows probably falls under shall. Reasonably believe is a may. Where do we get the, what is reasonably? Well, that's the same reasonably in any area of law, right? It's, what would another reasonable lawyer think? If the client has used the lawyer's services to perpetuate a crime or fraud. Actually, I think that one's pretty close to a shall, but whatever, it's in the may. Because sometimes maybe it just depends. The client is taking action that the lawyer does not like, which I kind of mentioned. Client fails to substantially to fulfill an obligation. That includes fees, right? So they're not paying you. You can consider firing them and withdrawing. well, that goes along with unreasonable financial burden. But you know, another example of failing substantially to fulfill an obligation is if the client is not cooperating. You know, you have discovery to do and they're not providing it. And you have to provide it. So those kinds of things are what comes up for people. And then it has the catch-all, other good cause for withdrawal exists. And then you have to comply with applicable law. Obviously, if it's in court, you have to ask the court. You don't get to just withdraw. And then the court, you know, sadly, can tell you that you still have to withdraw. Excuse me, you still have to continue, even if you don't want to. And that's where the issue comes up all the time about what can you tell the court, which I'll get to in a minute. When you do leave a representation, you're supposed to take all steps reasonably practicable to protect the client's interests, giving them reasonable notice, trying to allow time for employment of other counsel. You know, you can ask the court, if you're asking the court, to give them extensions and things like that. You're supposed to be obviously considering about what harm will happen to them, you know, what you can do to make it as less of an impact as possible on their case. You do have that duty to think about those things. That doesn't mean you can't withdraw. And then it talks about, there's a line by Robert Kuhn that talks about giving them their file, okay, or giving the next attorney their file, which is a sub issue. Yeah, you have to give them their file. So then I just went through the language. I wanted to talk about ER 20-0001. EO, this is a new ethics opinion that came out from the ethics committee appointed by the Supreme Court. So the difference, for those who don't know, and probably most of you have heard this before already, but the state bar always had ethics opinions. They're still available on the state bar website, but they were never binding. They were advisory only. The new ethics opinions from the court's ethics committee are decided on, approved by the Supreme Court. So therefore, they are binding. So it's a big difference. They can be used to defend you in any bar matter, which, I mean, fairly saying the old ethics opinions could be used too, but sometimes, you know, they weren't given as much effect as they could have been. Sometimes it would be an argument, you know, like, well, I read this ethics opinion said that, and the bar might be, who cares? Well, there's no more of that, you know, because if the Supreme Court ethics opinion says it, you know, the bar has to go by their interpretation. Okay, so this ethics opinion, it goes over the older one and reiterates some of it, clarifies some of it, and adds some new things. So it's definitely worth looking at. You can reach these from the bar's website and also from the Supreme Court's website. And it says that, you know, the general facts are the lawyers have raised many questions about their ethical obligations when they decide to withdraw. And that usually involves the intersection of ER 1.16 withdrawal and ER 1.6 confidentiality. And then they ask, you know, if they can charge fees, etc. So I don't want to go into all of that stuff here. We just want to call your attention to this opinion so that you can look at it if you want to, but it includes things like, can you charge for withdrawal related work? I do want to focus on what confidential information can be disclosed by the withdrawing counsel. So, like I mentioned briefly, a lot of times when people want to withdraw, they want to tell the court, this guy's not paying me, or sometimes they go a little too far, you know. This guy's just a jerk, like I think I had in my in my hypo. He drives me nuts. I hate him. I can't stand. I mean, I'm exaggerating slightly, but that does happen. So you can't tell the court what a jerk the client is, and that includes significantly problematic things that the client might be doing, because you're bound by confidentiality. So the trick is in comment 3 to ER 1.16, it tells you what to say. If there are some ethical issues that you are concerned about, but you can't tell the court, it tells you what to say. So always remember, look for comment 3. It says, professional considerations mandate my withdrawal, or something like that. I'm just going by memory here, but something like that. Professional considerations mandate my withdrawal. And that's supposed to alert the judge that there are issues that you're uncomfortable saying, but that for whatever reason you may not be allowed to say, but there are issues, right? And the judge is not supposed to give you a hard time about that. They know. If they feel they want more, though, they can order you to disclose this information. When there is an order, then you can disclose the information. There are other quibbles. This is again a topic where, again, I hate to sound like I'm just selling my services, as I'm not. Call anybody, call the ethics hotline, whatever. You don't have to call me. Read the comments, read the opinion I just mentioned, because it's very helpful about that. But there are other things in the comments, like you may have to appeal that order if the client does not want you to disclose this particular information. But generally speaking, once you have a court order, the court order trumps. Remember that a judge can do in-camera hearings. There are ways to protect this confidential information. If, for example, think about if the confidential information is against the client, it allows you to withdraw, but it would hurt the client's case if the opposing counsel knew about it. So, you know, those are the kinds of things that you can ask for in camera review if you need to. So sometimes these get a little bit tricky. But I feel that this opinion 2001 really does go into, is very helpful for going into different fact patterns that can happen. Another issue that comes up is whether you can disclose information to defend yourself. And generally speaking, you know, like if the client submits fraudulent evidence, those are special cases that really need to be considered and thought about carefully, so you don't get yourself in more trouble. So it's, again, another instance where you need to review the ethics opinions, consult with someone if you can, an ethics attorney or the hotline. The hotline used to have all these certain qualifications about things that they could and could not talk about. But that has loosened considerably. They want to help, and the ethics counsel on staff wants to help. They're going to help as much as they can. That may just include pointing you to an ethics opinion, but it's worth trying it because it's free, right? You know, and then if all else fails, maybe you want to talk to an ethics lawyer that you have to pay, but you want to be careful if it involves disclosing confidential information, and if it involves the client possibly being involved in fraud, crime, that kind of thing. Let's see, what else did I want to point out in there? So back to if it's defending yourself, if the client is saying bad things about you. reasonably, the 1.6D confidentiality gives you that out to be able to defend yourself. Again, it's a tricky area. You ordinarily just cite the comment 3, like I said. But in some cases, the client is saying things so bad about you that you feel that you may well be looking at a bar charge. Like, is the client saying this to the judge or the opposing counsel or whatever? So you look at what reasonably necessary means. And in this opinion, like I said, 20001 goes through that as well. So it can be helpful if you're in a situation like that to look back at this. Let's see, what did I want to say? You can't just open your file to any derogatory allegations, right? You can only defend yourself if you believe it's reasonably necessary. A bar complaint is, you are allowed to defend yourself to a specific bar complaint. Of course, the client at that point has waived any confidentiality and you can defend yourself fully. The problem comes up when it's in other areas where the client is, talking to the court or the opposing counsel or that type of thing. So in those situations is where it's a little bit on the fence and you want to look back at opinions and see what you can do. For example, there's also a newer ethics opinion, one of these EOs that somebody has underlined, not me, that goes into when your client has presented fraudulent testimony to the court. That's like one of the trickiest situations that any of us ever face. Okay. So there is a specific ethics opinion you can look at for that tells you how to handle it. In Arizona, you do have to disclose that in certain circumstances. So that's one you want to look at if your client has submitted fraudulent evidence, which includes fraudulent testimony, fraudulent filling out of paperwork, etc. Let me see if I had that one printed. I do not have that one printed to tell you, and I should have. Apologies. Okay, moving on. Number 4, I'm leaving a law firm and they won't give me any of my client files, my client lists, and they won't do a joint letter with me. What should I do? Okay. This comes up a lot. So let's talk about it. First, I made a little jokey. They're not your files, but everybody says that. Well, they won't give me my files, and the firm's like, we're not giving you our files. They're not either of your files. Okay, the files belong to, guess who? The client. The file belongs to the client. So that's your first consideration. So then, this is one of the older opinions, still very helpful though. 1002, not the new Supreme Court ruled on, but they only go over ones that I think so far that I've seen, they're only going over ones they feel like need some clarification. So the question presented in 1002 is, when a lawyer's employment with a law firm is terminated, what are the ethical obligations of the law firm and the departing lawyer? This helped a lot because for years, ever since I can remember, this one always comes up. They're leaving and they want to know what they can take or who they can talk to. And a lot of some firms are perfectly reasonable about it. So I don't want to say that everybody is unreasonable. Many places are perfectly reasonable. Unfortunately, just as many are not. so it becomes an issue rather frequently. So this opinion clarified. There was an older one also, but this one really kind of hammered home the points from the older one. And the good thing about the ethics opinions is they always talk about the older one as well in there. So it clarifies that when the lawyer leaves, both the firm and the leaving lawyer have ethical obligations to notify the affected clients, to avoid prejudice to those clients, and to share information as necessary to facilitate continued representation and avoid conflicts. These obligations, ethical obligations, can best be satisfied through cooperation and planning for any departure. So that's the best way, right? Now, does this always happen? No, of course not. But that is the best way. You're going to leave, you go and you talk to the partner or whoever it is you're working with, and you work it out. You do a joint letter. That's what we prefer, okay? Of course, people don't always want to do the joint letter, but that is what we prefer. Okay, what are the important parts that are in 1002? Important is the notifying the affected clients. And like I just said, our ethics opinions and anybody at our bar will say, we really prefer the joint letter. You know, we're all grown-ups here. We need to be able to get together and write that letter so that, you know, each person's position, where they're going to be is clear, because it's up to the client where they want to go. The client is not property of the firm or the lawyer who brought them in. It is the client's choice of who their counsel is. And so the ultimate goal is giving the client the information and letting them know where they want to go. Or excuse me, letting them know where they can go, their options. So, you know, if a lawyer is leaving a firm and they're not going to stay in the same practice, then, but you still have to tell the client the lawyer is leaving, but you don't have to add that component of, and here's the lawyer's contact information if you choose to go with them. So it, you know, like anything else, it varies with the facts, but the one that mostly happens, of course, as I've been saying, is that a lawyer is leaving and they want to take clients, and the firm does not necessarily want the lawyer to take clients. So the opinion makes it clear, as I said again, that the firm cannot refuse to tell the clients that the lawyer is leaving. The firm cannot refuse to let the lawyer give the new contact information. Nothing like that can happen. This is from 2010, and you would think that it wasn't happening anymore, but it is still happening. So that's why I added it as one of the top 10 questions. It still happens. We still get calls all the time, and people are fighting. And I guess, you know, it goes back to the what we say a lot of times when we call it a business divorce, right? When a firm is breaking up or just somebody's leaving, whatever, it's oftentimes similar to a divorce, with all the personal emotions that are going on, and people are angry. And when you're angry and you're mad, you're not always thinking, you know, as logically as you should be about it. So looking at the opinions can help you get back on track. Talking to an ethics lawyer can help you get back on track. Frankly, you know, talking to a colleague can help you, you know, think through this about not getting all worked up and doing things that ultimately hurt the client. So, like I said, 1002 goes into notifying affected clients. It lists older opinions that say basically the same thing. It gives you the applicable rules. It tells you about informing the client and the client's right to choose counsel, which I just went into. It also talks about avoiding prejudice to the client from the departure of the lawyer and ensuring that both parties have sufficient information to fulfill their ethical responsibilities. And those last two kind of go to like avoiding prejudice to the client from departure of the lawyer. So if one lawyer was the main lawyer working on the file, and then that lawyer's leaving, does the firm have the knowledge of what's going on in the file to keep up with it? Do they know about the deadlines? Do they know what's happened? Has, hopefully the leaving lawyer has some sort of file and has updated it that somebody can look at, but do you know? You don't know until you talk to them. So it's another reason why, you both have that duty to talk to each other, no matter how upset you are, because your first focus has to be the client and what's going to happen to that client's case. Are there deadlines you need to know about? Those types of things. So, and then ensuring that both parties have sufficient information to fulfill their ethical responsibilities also goes to the things I just said. Are there deadlines? What do you have to do? Who's going to do it? It also goes to conflicts. So, a leaving lawyer that's going to another firm has to be able to look at conflicts. And so, part of the opinion goes into those sort of practical details that people don't think about, confidentiality, and they're confidential, but you're going to another firm. Well, this is another reason for the joint letter, the client deciding where they want to go. If the client decides they're going with the departing lawyer, then they have to be able to get their file from the place that they're leaving promptly so as not to harm them. The departing lawyer needs to be able to check conflicts if they are going to another firm. That firm needs to be able to check conflicts. So there's, interaction that has to happen that can't happen when everybody's mad at each other and that type of thing. So those are the kinds of things that it goes into. Let's see if there's anything in particular in here that I wanted to point out. I guess the main thing that I wanted to point out was what I've already said. The client is the one who gets to choose. Okay. And that's in there very clearly. The client is the one that gets to choose. So, so the joint letter should give them that option. The best ones have a place for a signature and say, please let us know whether you would like to stay with firm X, go with lawyer Y, or you are free to go to another lawyer of your choice. Please fill it out, return it to us, and then we'll know. Now, whoever it's returned to, this is another quibble that comes up. Whoever it's returned to has an absolute duty to share that information with the other one, right? So, the lawyer knows that the client's going with them, they have to tell the firm. The firm knows that the client is staying with the firm, they have to share that with the lawyer. And know them just saying so is not really good enough. They should be sharing the letter itself. But then this is the next one, but I forgot I wanted to talk about briefly. How do you know if the departing lawyer has the right to contact the clients? Because that's another big thing that comes up. So the rules tell you, but also this opinion goes through it in detail too. The analysis assumes, I'm reading from the opinion now, but it's also in the rule, that the departing lawyer had a significant enough role in the representation of the client that informing the client would be reasonable and necessary. So if the associate, giving an example of like a medium-sized firm, if the lawyer was an associate and just billed, an hour on a file that is a 100-hour file, that's probably not significant enough that the lawyer has any right, or the client needs to be told. Okay. So this is another sort of judgment call that can come up where it helps you to talk to someone or to look at this letter. If the lawyer was the client contact, even if the lawyer, say we're talking about a big firm, right, and they weren't the one who brought the case in, whatever they call that, I forget, or they bring the case in, they get some money for it. But if the lawyer even was a junior lawyer, but was the contact, to the client, then that is significant enough contact that the client needs to be told. The client should not have a situation where they've been dealing with Harvey, you know, for regularly, and then Harvey leaves and they're not told or offered the opportunity to go with Harvey. So that's another little wrinkle that people need to think about. You know, of course, there are some cases where the lawyer that's leaving wants to bring all these files, but never had any contact with many of them. That does happen. More often than not, though, the lawyer had plenty of contact, but the firm doesn't want to let the client go with that lawyer. So the ultimate thing you have to remember in all of this is the client is king, basically, or queen. The client decides, the client whether the client's interests are predominant. So hopefully that gives you enough information on that one. Was there anything else important? No, I went over everything that is important. Of course, more detail in the opinion, you can always look at it. Oh, there was one other thing. You want to avoid charging excessive fees in connection with any work done as a result of the departure. Sometimes we see that, and that's not a great idea either. It's not fair to the client. So you want to give the client the notice timely as possible to let them make informed decisions about their representation. You want to work to ensure, and this is best to do together, that the continued representation of that client is diligent and competent. You want to avoid charging excessive fees, and you want to share information as necessary so that both sides are fulfilling those duties to that client. Okay, now, moving back on to number 5. Another question, do I really have to give money back if my flat fee turns out to be easier than I thought? Or what if the matter went on for 5 years and now I can't finish it? Do I have to give the money back? Let's just think of an example of a flat fee of $10,000. You know, do you have to give it back? Oh my gosh, am I running out of time? Sorry if I am. So let's see.
Denise, my suggestion would be this. You go ahead and cover your materials. I will be posting the CLE cert at the hour mark for 1 hour, both CLE and ethics credit. You go on with the rest of your materials, and those who want to stay and get a modified certificate for additional credit, we will certainly be happy to do that, but the recording will be the full breadth of your presentation. All right? Okay.
Yes, I apologize. I just was talking too long about this.
All right, you're a great program. Thank you.
Okay, so we're looking at ER 1.5 to talk about whether you have to give back any of a flat fee or not. Again, the language is important. So a lawyer shall not make an agreement for, charge, or collect an unreasonable fee or unreasonable expenses. And then it goes through the factors, which everybody has looked at. I just wanted to call attention to those words because it means you don't make that agreement to start with. If there is an agreement that you made, you have to look back at the end because you also can't charge it or collect it. Okay, so that language basically ties into what we all know about as the Swartz case. Don't forget to do the look back. That's what we learned from the Swartz case, right? And the profession has an obligation of public service. That's the language that's in there. That's in the Arizona Attorney's Fees Manual. This is our sort of seminal case, okay? Now, besides Swartz, there was also a later one Hurwitz or some Hirsch, I forget now, but that basically focuses on the language from Swartz that says this is not an ordinary business contract. That's the number one thing to remember, because people tend to think, oh, contract rules. Well, it's not an ordinary business contract. We have a fiduciary duty, and that's partly why it doesn't matter if we said in the contract that we get to charge X. That doesn't matter. It still has to be reasonable. It has to comply with ER 1.5 and the descriptions in cases like Swartz. And then I had an example case. I always use this example case, although I think it was maybe just cited a little bit wrongly. but aside from that, it's there, so it ought to scare people, and they should know, it can happen. It was a wrongful death case, 33 1/3%. The lawyer sent a demand letter. There was $100K available, and only by insurance, they said, we'll pay it. Client accepted. Lawyer voluntarily reduced his fee from 1/3, which was $33,000, to $30,000, so like $3,000. The bar found the fee unreasonable, and the lawyer was ordered to pay $23,000 in restitution. The lawyer was also suspended for 30 days, but it was not solely because of this contingency fee issue, because that really freaks people out, because a lot contingency fee lawyers have the 33% a lot of times, and it's not just that. Okay, there were other issues that the lawyer was suspended for. Nevertheless, it is a serious case to be thinking about, to remind you that you have to do your look back. The bar found, that there was just not enough work to be taking 33 1/3% when all the lawyer had really done was a demand letter. Okay, so keep that in mind. I guess I already did this at the outset. Shall not enter into, charge, or collect. That's the language I wanted to focus on. And then we get to the flat fee stuff. I think that most people know this by now. You can use the earned on receipt language. You can use the non-refundable language in your fee agreements, but at the same time, you have to tell the client in writing that they can nevertheless discharge you and may be entitled to a refund. Okay, and why do you have to tell them that? Because that's the way it is. It doesn't matter if you say you have a flat fee of $10,000. If you didn't do some work for that $10,000, you don't get to keep it. It's just, that's the way it is. Okay, and there are lots of cases like that, not just Swartz. And then I had another example, earned on receipt. I thought this one was kind of sad to me, because the lawyer, clearly I don't think the lawyer had the money to pay back the money, but whatever the case, the lawyer did the look back, didn't pay it, and ended up in big trouble. Conditional admission of the violations, and was suspended. There were some priors, and one was similar. So that's part of why it was such a significant sanction. Again, and I put query if inability equals a dishonest or selfish motive. I don't think personally that part should have been in there, but the respondent was not represented. So I'm not saying they get off the hook if they're unable. They don't. But the issue, if they can't, that's not dishonest motive to me. If they can't, if they're unable. And then there's Hirschfield, using the non-refundable retainers, kept the full amount no matter how long he represented the client or how much work he did. And the court also goes back to Swartz. It is not an ordinary business contract. And I say, note, Swartz and Hirschfield are not limited to flat fee or earned on receipt fees. They are not limited to contingency fees. All legal fees must be reasonable. I've had people say to me, oh, Swartz only stands for contingency fee. Well, you can make that argument. It was a contingency fee case, so we can all argue about case law. But it's cited in every, by the state bar and all their publications about fees, all their CLEs, and I put an example, Arizona Attorney Fees Manual, the ethics section, it says it is not limited to a contingency fee case or a flat fee or an earned receipt. The key thing to get out of it is that our contracts are not an ordinary business contracts. We are fiduciaries, and we have a duty to make sure our fees are reasonable. We cannot charge or collect an unreasonable fee. So if you have a client saying that your fee is unreasonable, even if it was just a regular billing matter where you're billing by hours, you still need to look. You still need to do the look back and decide. Okay, I'm talking fast now because I realize this is. So can Charlie client pay me with a wedding ring? Of course, it's not always wedding rings that people ask about. Can Charlie pay me with a deed to a property? Can they pay me with whatever they do? Say, they're a doctor. Can I get treatment from the doctor? Whatever. Could be anything. So, but in one form or another, it comes up all the time. So the rule to look at is 1.8, conflict of interest, current clients, specific rules. Just a little side note, although I'm taking too long, 1.8 are examples of conflicts that are, all of the examples in 1.8 are also 1.7. 1.7 is the general conflict of interest rule. 1.8 gives you specific examples because of ones that come up a lot that people, I guess, for years didn't think were conflicts. I don't know, but for some reason, whoever came up with model rules in the first place, they're like, we're going to give some specific examples. They're also a 1.7. So if you ever get charged with any and you're wondering, why has the bar got this in there? Because if it's a 1.8, it's also a 1.7. Okay. So the specific example here is a lawyer shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory, security interest unless, and then it gives you the factors you have to disclose. The transaction has to be fair. It has to be disclosed in writing in a manner that can be reasonably understood. You have to give the client the advice that they should seek advice of another independent legal counsel, and you need to give them time for that. So having them sign it right there with you is not giving them time for that. So if you're going to do something like this, keep in mind, you want to tell them, give them this writing and stuff, and give them a few days to think about it. That just looks much better because obviously then they have time if they want to talk to somebody else. And then the client has to give informed consent to the essential terms. But informed consent is what our rule says. A lot of people call it waiver. When you always heard about doing a conflict waiver, what it really means by our rule language is getting informed consent. And informed consent has a whole lot of requirements in it, and it's defined in 1.0. This M I put in here because it's new. It was added with the changes to the rules for the ABSs. If you remember, when they changed the rules for the ABSs, they got rid of the 5.4, one of the fives that said you can't engage with non-lawyers. And they also got rid of the other 5 rule that had to do with law-related businesses. So for the old rule of law-related businesses, it kind of had this language in there about if you're going to engage in a business transaction, you have to comply with 1.7 and 1.8. When they got rid of the law-related business one, they realized they've got to have this part because this is still going to apply if it's an ABS, even though an ABS is allowed, it's still going to apply. And this was part of the goal of this, was to make sure that even though we're allowing lawyers to work with non-lawyers and to have law-related businesses that are owned by non-lawyers, we're still remembering that we're governed by our own conflict of interest rules. So that was clarified in there, but it goes to the, you know, anything like swapping for a ring. 1.7, I'm not going to read it to you since we already talked about it. But like I said, it's 1.7 is the basis, 1.8 is specific examples of the conflict. And then discussion, this was the old case that was actually about rings. That's why I used rings for the example, but there's been artwork, there's been all kinds of things. So client asked the lawyer to purchase her wedding rings to help pay the fee. Yes, it was a divorce. The lawyer did tell her to go to a pawn shop, but she didn't like what they offered, went back to the lawyer. He ended up giving her $500 for the rings. What happened, even though this is 1993, the court found that he violated 1.8A by entering into a business transaction without providing the client with the opportunity and notice that she should seek independent counsel. In addition, he did not obtain her written consent. Okay, and that's how people get in trouble. Even if it's a fair deal, you can still get in trouble if you don't jump through these hoops, you know. So it doesn't mean you can't take a wedding ring. You absolutely can. You just have to be careful that you jump through the hoops. Maybe it's better to just avoid it. But let's face it, there are clients who have things and don't have money, and you know, you want to help that client. So you don't rule it out totally. It's possible. So these are old cases back when we had the matrix and I could figure out what cases said better. I don't have the matrix anymore. So this 2008 to 2010 doesn't mean they're not still happening. It just means I can't find them as easy. So in between there, I had noted 15 discipline matters involving 1.8A business transaction. They basically can be summed up as barter trade cases, loan cases, law-related services cases. And then I gave some specific examples of things that people did. The one that is the most problematic, in my opinion, is lending money to a client or borrowing money from a client. Loans are a serious, serious matter. That's something I really don't think should happen. It can happen with the informed consent, but that's one I would avoid, where I'm not so worried about, you know, bartering for something, you know, that you get the value of and it can be clear what the value is, or referring somebody to a business that you have an interest, you know, that even with the ABSs, that's more allowed. Loans are high risk, and I don't, I personally don't think it's a good idea ever. Certainly you better get some advice before you do it. 7, what can I do with all the old files I have in storage? Okay, this one hopefully is going away somewhat because of people keeping things online now. But you know, this picture here, for those of us who've been practicing for a while, this was a thing. you could have piles of these things. Your garage could be full of these things, and you know, what the heck do you do with them? So one of the new opinions revisited an older opinion and clarified it with modern day times. So it gives you all the advice you need to know about what you can do or what you should do. You make a reasonable effort to return the file to the client. Tell them they're going to destroy the file if the client can't pick it up. That kind of incorporates that. If you have that in your fee agreement, it's a good reason why you should have that in your fee agreement, where you're telling them, I'm going to keep a file for X number of years, and after that, I'm going to destroy it. Please sign if that's okay. Okay, so then you've covered that. That's why we have that in fee agreements. If there has been that effort and you've tried to find the file, then you treat it as abandoned property. And this opinion will go through all of those details for you. How long do I have to keep files? Can't give you a clear answer. Everybody hates that when you can't give a clear answer. All I can tell you is, you know, there is no one size fits all. Look at that opinion to consider what applies to you. And the reason is some cases have legal requirements, right? Like some probate cases or guardianship or criminal law cases have their own legal requirements about things. Others don't. I only keep files, I keep files less than a year now because I don't have none of those things apply to me, but it just depends on what kind of files you have. But it does say at a minimum, the client must be notified before files are destroyed. It is advisable to communicate early about file retention policies, and there I put it in your fee agreement, have them sign that fee agreement, okay? What items do I need to keep in the files? This is also helpful in this opinion. This is a helpful thing because there used to be arguments all the time. What was in the file and what you have to give to the client. Do you have to give them your work product? What is work product? These things are all addressed in there. And it's a helpful opinion to lawyers because it says lawyers need not keep all materials generated in the representation as long as these certain materials that it lists, which include information regarding the work done to permit the client to understand what was done. If that's kept, that's enough. Okay, so you don't have to keep every little chicken scratch note that you wrote on whatever and send that to the client. This helps because the bar, with bar matters, sometimes in the past, they would want to get the lawyer's file and they would want, all this stuff that maybe the lawyer didn't necessarily keep. I'm not telling you don't have to keep important things, because you do. What I'm telling you is to read through this opinion and look and see, what it says is important. It's pretty good. It's pretty clear. Okay. It's not every single thing under the sun. It's only what's relevant that you have to keep and that you have to transmit to the client when they leave or to successor counsel. Do you have to give the client a second copy at no charge? That one was such a debate for years that thank goodness, it's very clear in this opinion now. And the Supreme Court okayed this opinion. Okay. No, you do not have to give the client a second copy at no charge if you have provided a copy during the representation. One copy is included with the representation. So this is another place where you can use your fee agreement to save you a lot of problems later by explaining in there, whatever your practice is. For my practice, I explain I'm going to email them everything that's important to them that happens. And so they're getting a copy all along. When the representation ends, if they want a copy of what I have, I will give it to them at no charge. If they ask me again, then if I have it and it hasn't been destroyed, I may charge, at a paralegal rate to find it and get them what I have, but I don't keep it forever. So this is also an opinion that is actually helpful to us lawyers. What do I do with unclaimed trust account funds? When the lawyer can't find the client after reasonable efforts to do so, they should dispose of the funds in accordance with state law. And I've got your relevant ethics opinion in here, even though it's old. This one is still good. I mean, anyone that's up there is still good. It's just that the older ones were persuasive authority, but not binding. But they're still good and they're very helpful. And this one is very helpful. It tells you about the Unclaimed Property Act, tells you how you get it to them. What if the lawyer has money in the trust account and does not know to whom it belongs? Okay, this is a whole nother issue. You should know where it belongs, but sometimes that happens. It's the same opinion, though, that you look at to tell you this. The inquiring attorney has a small amount, can't tell whose it is. He had an accounting firm go through it all and do everything they could to figure out whose money was whose, doesn't know, and believes he will never know. What should the inquiring money do? If you're holding excess funds in a trust account, you dispose of it pursuant to Arizona's Uniform Unclaimed Property Act. So, if that latter happens to you, you want to talk to an ethics lawyer, not necessarily me. And the bar is fine, the free, but talk to somebody and read the opinion to think about how you do it. Because the key there, I think, is that you have to have made efforts to have figured out whose it is. Your efforts have to have been reasonable to figure out whose it is before you send it to Uniform Unclaimed Property Act. Okay, do I need, we're getting close. Do I need to have a trust account? It depends. That was helpful, wasn't it? But the State Bar's website now on the Practice 2.0 part, they have a lot of written information that you can look at. They have a really long manual that is extremely helpful if you have a trust account. But besides the really long manual that we know nobody wants to read, there's a short one, like a primer. And that in itself is very helpful. They're all available on there. Sometimes it's a bit of hunting and pecking to find where things are. I think I was going to go through all that, but we don't have time. So basically, I'm just saying, see the State Bar website. Number one, you should not be scared to have one. If you're required to have one, don't be scared of it. It's not that big of a deal. If you read that little manual, you will figure out how to deal with it. If you cannot figure out how to deal with it, go to one of the classes. Once in a great while, I'll do one, not that often, but Tracy does them from, oh gosh, I can't recall where she works now, but she used to work at the bar. The bar does them. You don't have to be embarrassed to go to it. You can not even bring your paralegal or your staff to go to it, because that will help you. And they make you do it hands-on, and doing it hands-on teaches you. So even though it's a pain in the butt, once you do it hands-on, you're like, oh, I get it now. Okay. Related questions. Does the money go in the trust account? Who is responsible for the trust account? What is a three-way reconciliation? Okay. Again, that manual will help you. The basics short version will help you. CLEs will help you learn it, but just quick answers. What goes in the trust account? Other people's money. Okay. It's a short answer for you to remember. OPM. Other people's money goes in the trust account. It's not yours, goes in there. Okay. Sometimes your money's going to be mixed in, like when a settlement comes. In that case, it goes in there at first and then it is taken out. But if you have a mixed amount and the amount includes other people's money, it goes in the trust account. Who is responsible for the trust account? You are. That's a non-delegable duty, which is why you need to read the manual. You need to understand things, go to a class, etc. Yes, you can have staff work on your trust account. That is not but it is not a non-delegable duty, so that if there's a violation, you are still responsible. That's why you have to understand what's happening. If you don't understand what's happening and you just let your staff do it, your staff can be ripping you off. And that's, of course, worst case scenario, but it happens all the darn time. And aside from ripping you off, they can just be making mistakes. And again, when the mistakes are found by the bar, it's not the staff who's going to get in trouble, although you may get them in trouble, but the bar is going to get you in trouble. So you have to know. What is a three-way reconciliation? We don't have time, so I'm not going to go into huge detail about it, but it's actually very simple for people who think it's horrible. If you're older, you probably used to have a written checkbook. That's the easiest way to explain it, but I know that people nowadays don't bother to have their written checkbook. But the written checkbook is what you have to have for each client. And that's the part of the three-way reconciliation that people don't get. Your trust account statement tells you how much money's in the bank. Okay. Your general ledger, where you've entered every deduction and all that, is number 2. And it should tell you how much is in there. But by themselves, neither of those 2 items tell you whose money is whose. They don't tell you the client's money. So for that reason, the third item is a client ledger. And the client ledger is like the client's own little checkbook. And it tells you which money is that client's. Okay. Oh boy, we're to number 10 and we're only 20 minutes late. Can my assistant do client intake for me? What kinds of things can my assistant do for me? This is a pretty common one also. There is a fairly recent ABA opinion that I've listed here that gives you some guidance. It says client intake is doable as long as the assistant has been properly trained. Again, you have to have training, but you have to recognize that different states have different views. So you can look at ABA opinion for help, but it doesn't necessarily mean that Arizona is going to be the same. For example, 506 thinks that an assistant may obtain a prospective client's signature on a fee agreement as long as it does say though, as long as the prospective client is offered an opportunity to communicate with the lawyer. Some could read this to think that a client doesn't necessarily have to meet with the lawyer if they're just given an opportunity. However, our state bar reads the Phillips case. I knew someone would bark, apologies. Reads the Phillips case, and mostly everybody knows who Phillips is, right? To hold that non-lawyers are not permitted to have, sorry, this is cutting off my view, are not permitted to have clients sign engagement agreements without attorney involvement. Okay, in Ray Phillips 20, I put the site on there. You also want to look at the ABA, you also could look, sorry, at the ABA model guidelines for utilization of paralegal services. That's something available online. I'm not saying it answers the question about non-lawyers signing, etc., but it does give you a lot of examples if this is the kind of thing that you are wondering, what can they do? What can't they do? The model guidelines give you a pretty good idea. Obviously, they cannot give legal advice. They're not allowed to establish the amount of a fee, that type of thing. And I don't know, I think I've got to number 10. So I will go ahead and stop with there. I did have a little list, some specifics. And I made a star. This list is from Linda Shealy. I want to give credit where credit is due. I did a CLE with her at some point, and this was in her part that she did. She had made a little list that she probably provided to people who hired her. But the list can be handy. Like it says, non-lawyers may not enter into fee agreements with new clients. Same thing as the state bar says, cannot sign pleadings, cannot give legal advice. So that could help you looking at those. And then there's your ACBC disclaimer. And I apologize that I ran over. But I'm done now.
All right, so we have some questions. I'm going to go through that. Now, for those of you who stay through the questions, I've got an amended CLE cert for an hour and a half. So I'll post that at the end here. Otherwise, you've already received the 1 hour CLE certificate. All right, so let's see. Joy wants to know, what language do you put in your motion to withdraw as the basis?
Go back to that comment, which I think is comment 3. Look at 1.16 and read the comments. I think she's talking about what language, the specific language that you put if there's a problem. Otherwise, you just put generic language.
Okay. And she goes on to say, does the client waive confidentiality if choosing to participate when choosing to participate in a fee arbitration?
Yes, to a certain extent. I should qualify even with a bar charge. One thing that sometimes happens when people represent themselves is they're so mad that they respond to the bar charge with unnecessary vitriol, or so yes, you can respond to a charge. That doesn't mean you get to say everything the client ever did, unless it's relevant to what the charge is. So you don't say, this client, kicked their dog, unless it's relevant to what you're addressing. And that's the same thing with the fee disputes. But yes, the bills are coming in. The bills have a lot of confidential information. Those rules are on the bar's website under fee arbitration. The petition rules are on there. So I would say the answer is yes, they've waived it to a certain extent, that extent being what is reasonably related.
All right. I missed some of the beginning. So Jim Kahn asked, does the state bar license and discipline the new paralegals? To whom do we report substandard performance? So you might bring, not everybody might be aware of what has gone on there, Denise. So you might do a quick summary as to what it is Jim's referring to. But I'm also really wondering about this because I've seen some pretty crappy work.
Well, that's interesting because we're actually doing a program for Pima County Bar Association that I am put together because somebody asks like a similar question that's on the CLE committee. I don't think people know practically how to deal with these people, what they're actually allowed to do and what they're not allowed to do. And for the background, when the rules changed with allowing the ABSs, alternative business systems or services, I can't remember, it also allowed a licensed paraprofessional. So this is a little bit a step up from doc prep, which Arizona's had for a long time. We've had people who were allowed to do doc prep for a long time with authorization from the court. They are regulated by the court. These legal paraprofessionals are allowed in certain categories. And there are quite a few categories that they are allowed in. There are, you know, even in family law, they can go into court. But what can they do? Can they do everything or only some things? That's the practical aspect of the program that we're going to put on. I have the professor from U of A. U of A has a program that is licensing these people. Last I heard, there were 50 or something, but it's going up. It's regularly going up because U of A has this program. So she's going to be on the panel, and Marilena Cruz, Judge Marilena Cruz from Court of Appeals, because she was part of the whole committee doing, you know, recommending these changes and doing these changes. And some of the questions we're asking are, you know, practically speaking, please tell us what they're allowed to do and what they're not allowed to do, because we need to know if we have to report them for UPL. Are they UPLing or are they not UPLing? You know, but back to the actual question was, where do you report them? You still report them to the state bar. The state bar, that's why the rules were, a lot of the rules were changed to add in language about ABS or legal paraprofessional. Like maybe the substantive rule wasn't changed, but just adding in those words to let you know that the ethics rules apply to them. So you can report them to the state bar, be it the legal paraprofessionals or the ABSs, both of them. Now, again, if you're reporting a legal paraprofessional and it turns out it's something they were allowed to do, then I guess the state bar will just tell you, hey, they were allowed to do that. And that's part of why we thought the program would be good, because, you know, we don't know. Like, I understand they're not allowed to do quadros, but they are allowed to do a lot of other family law stuff. What they're allowed to do in your scenario, Diane, yeah, I don't even know.
Okay. All right. And again, when is that program and where is that program going to be?
It's through Pima County Bar, and they charge $75 for people who aren't Pima County Bar member. I'm going to ask at the next meeting if we could reduce that, because I think a lot of people would like to see that one. It's going to be on Zoom. Probably if they won't reduce it, I'll probably see that I can use it somewhere else or something. I can have them
well, certainly you're welcome to call us, either Lisa or myself, and we can do another one of these wonderful programs. I invite our audience now, if you want to unmute yourself, if you have questions for Denise, now's the time to do it. I'm going to go ahead, because I promised I would, and post the 1.5 hour CLE cert. So that is now posted. You should be able to retrieve it off of the chat. So anybody have questions for Denise?
Can't promise I'll know the answer, but I'll try.
All right, I'm seeing a couple people unmuting themselves. So, Robert, did you have something?
No, it was a very good seminar, and it hit some of the really key points that, you know, the ethics rules have been in play about. So It makes it easier to find one of those things when you know where it is, but you don't have a grid to go after it anymore. So
Well,
thank you. You're welcome.
Yeah, I'm really sorry I went on so long. I guess it's been a while since I did it, so I forgot my tendency to tell you about every little detail.
No apologies. I get an extra half hour out of it.
Yeah, absolutely. No apologies. All right, this is the last chance. If you've got questions of Denise, let's hear them. Just unmute yourself, please. Lawyers who don't speak up. Oh,
I've got one question for Denise, if I might.
all right.
Denise, it strikes me that if the bar really cared about protecting the public, the bar would require that any lawyer handling a probate have malpractice insurance equal to the amount of the probate estate. Because in the number of years I've been in practice, I've run into a number of heartbreaking cases where the attorney has looted an estate, and the rightful beneficiary of the estate is left with a disbarred lawyer who has no way of paying back the money he's looted. And this they've done, seems to me, with the bar's compliance and facilitation, because the bar could just say, look, you need malpractice insurance equal to the amount of the probate estate you're handling.
Hmm. Well, I don't know about equal to the amount of what handling. That's a good point, but I do know we didn't used to have anything at all. And then we had the rule that you have to tell people about it. And now we have the rule just added to the new rules at some point last year, maybe it doesn't take effect till this year. Honestly, our rules change so much, I can't always keep up with when they take effect, but there is a new rule that says you have to keep the client updated about your malpractice insurance. So it has to be in your fee agreement. And then if you don't have it anymore, you have to tell them. So they're trying to do things that are short of requiring us to have malpractice insurance. Some states require malpractice insurance. Arizona does not. Even this reporting of it, faced a lot of pushback from a lot of Arizona lawyers. Let's face it, we're the Wild West, and we do not like to be told what we have to do. And there are some good reasons for that also, to be fair. I actually did a panel one time for April about requiring malpractice insurance. There are some good reasons why it shouldn't be required, especially for solos. It can be prohibitively expensive. And then there's also just the client choice matter. So I think that the balance was reached by saying you have to tell the client. We're not going to require it, but you have to tell the client. So then the client can choose. Do they want to go to somebody that has malpractice insurance instead? They may have to pay a lot more. It's a client choice situation. So yeah, I don't know that if I answered you about that. Or not, I'm sorry.
I think that you summarized beautifully the dilemma, the push and pull of that particular issue. So we're going to sign off unless somebody else has a question, and let Denise go get lunch and the rest of it. But I want to say thank you, Denise. This has been a wonderful program. You are a delightful speaker. So for everybody's use, this will be publicly available on ACBC's YouTube channel, and anyone can watch it. And of course, it is open for self-study. Those who are here get your the ACBC certificate, but for self-study, you can do that. So last call for questions.
Thank you very much.
Thank you, Denise. Okay, goodbye.
Bye.
Thanks. Bye.